We'll move on to item 2, Administrative File 2014-29. Our first speaker will be Judge Travis Reeds from Michigan District Judges Association.
Good morning again, Your Honors. So this is something that the District Court deals with on a very regular basis. In our court, it's almost a daily basis, and we think this is also an excellent example of where collaboration between the State Bar and the other organizations, which are our stakeholders, and how efficient we can operate, got together. We came up with perhaps a blended proposal. From the District Judge's perspective, we would suggest that you adopt the blended proposal. I think it's now called C, with a minor addition that the ability to waive the 14-day requirement of sub C2C's 14-day waiting period, that could be waived in the judgment. And that takes into account the balance between a landlord not having to wait longer, for example, in a landlord-tenant action, to execute their writ, as opposed to balancing people who may be applying for public assistance, or their funding for some of these things could be impacted negatively by entry of a judgment. With that being said, I think that our proposal adequately lays it out, our commentary, and if you have any questions, I'm happy to answer them.
No questions. Thank you for working together to come to a
What's that? I'm sorry, Justice.
Thank you for working together to come to a reasonable resolution.
I think this will work, actually, so thank you.
Good, right, Ann?
Karen Saffron, State Bar of Michigan Civil Procedure and Courts Committee.
Good morning, Your Honors. It feels weird I was just introduced, but I'm Karen Saffron, just repeating back my name back to you. I'm here on behalf of the State Bar of Michigan. I'm the chairperson of the Civil Procedure and Courts Committee. And just following up on what Judge Reeds just mentioned, what has happened is we were given option A originally, and then the suggestion was, well, pick A or B. And the State Bar and a lot of stakeholders went back and said, Your Honors, would you be willing to consider a third option, which has been colloquially termed option C, and that is what's laid out in the letter from the State Bar dated, from Janet Welch, dated December 20th. The purpose of the rule is to allow for some flexibility and creative process in allowing parties to resolve cases and to enter into judgments. The idea of a pocket judgment where you have your settlement agreement, and if somebody doesn't pay, then you can come into court and get a default judgment. The rule was created as a compromise effort. I believe that all the stakeholders are on board. There may be a couple of minor requests for minor revisions, and the couple of language changes that are in option C in the State Bar proposal. Rather than calling it the plaintiff or the defendant, the parties are now referred to as the defaulting party and the non-defaulting party. The reason for doing that is the plaintiff may not be the person who gets the judgment. If you have a counterclaim and you end up with a money judgment in favor of the counter plaintiff, the nomenclature may be a little bit different than simply plaintiff defendant. So that was the reason for the defaulting and non-defaulting party language that was used. The option C, I think, as proposed, does give the parties the ability to waive the 14-day requirement. I think what happens is that it's the default is if the judgment doesn't say, or the conditional order of dismissal doesn't say that a judgment can be entered immediately. So the parties haven't specifically negotiated for that, then you fall into the 14-day waiting period. But the parties are free to agree to something different and to waive the 14 days.
Is a default the same thing as a breach?
A default of I'm perhaps using both terms the same way. When you have your...
Well, I guess more importantly, does the rule use the terms? It at times refers to the non-defaulting party, at other times the breaching party.
Non-defaulting party, the breaching party. You're correct. So I guess we would need to clean...
The non-breaching party, is the non-breaching party different than the non-defaulting party?
I would say no, that should be cleaned up and it should be consistent throughout. Okay. I don't think there was
In intent to.
in intent. I did have one last point, if I may. Just
You may.
appreciate that. And that is in response to the creditors bar's letter, and the rule as set up puts the onus on the party who's seeking, the non-breaching party, to schedule the hearing in the event that there's an objection by the breaching party. And the creditors bar suggested that that be flipped, and that either the court should set the hearing, or the party that filed the objection should schedule the hearing. And I think that is consistent with the way the rules are currently, with objections to 7-day orders. However, in this instance, it may be more efficient to leave the proposal as is, because I think the party who has, of the three parties, the party that wants the judgment entered, the party that's objecting to the judgment, and the court, of the three of them, the party that is the most motivated to move this to a conclusion would be the party that's seeking the entry of the judgment. So that's the reason why it was proposed that way. And with that, unless there are any questions?
Seeing none, thank you very much.
Thank you very much.